I got angry about Thanksgiving, and then I realized it was just sad that we're not spending a lot of time together. And she was sad about it too, and it was exhausting for both of us. She was away from the boys, I was always dealing with the boys.
On a return from Serbia in December, but she only spent one day in Cohasset. And she was supposed to come home for Christmas morning. But she missed her early flight, and she couldn't get a flight, and then she had to drive up. The defendant told police there was an argument.
I did have an argument with her for the Thanksgiving and the Christmas Eve, so I wasn't going to make the same mistake 3 times.
So what did the defendant do on Christmas Day when his wife wasn't home? He looked up Bethesda on his cell phone. The man his wife had just spent the night with. The defendant was losing Ana. Ana was missing her children and wanted to be down. Ana quickly returned to D.C., and on December 27th, the defendant was looking up the best strategies to divorce for a man and the D.C. divorce laws. This was not to protect assets. That wasn't the search. The defendant told the police that everything was in Ana's name. The defendant had nothing without Ana and the kids. And on December 29th, Ana spoke with General and told him that she was upset. Upset about the travel, upset being separated from the children, upset about the defendant's federal case. It was ongoing. It was getting to be too much. On December 29th, Ana went out with Alyssa Curry. And she broke down. This strong Serbian woman who was supposed to be having a fun night out with a girlfriend, going to dance karaoke, instead broke down. Ana told Alyssa that she had told the defendant that he needed to take responsibility for the federal case, go to prison. She wanted the children with her in D.C., and she and the defendant had not been intimate close to a year. In Ana's mind, the marriage was broken. Ana even questioned if she could just take the children because she had already established a separate household. She said that she was falling out of love with the defendant. And at home in Cohasset, what was the defendant doing? He was looking up the Mazda building and the FBI raid on the Crossing building. Looking up something that had happened in the spring of 2022 when Ana first started working for Tishman's Fire. Interestingly, this was when the defendant brought up something he brought up in his interviews, when he lied about Ana having to leave early for a work emergency. He was planning the work emergency. The defendant was going to lose Ana, and when he lost Ana, he would probably lose his freedom. Ana would have a house in D.C. and a nice job, and he would likely go to jail. So the defendant pretended. He lulled Ana into thinking that everything was okay. He joked with her about a Porsche. He didn't want her to realize that he was aware of the relationship with Will or her ability to leave him. He wasn't going to let Ana know that she wasn't safe. On December 31st of 2022, the defendant claimed that he could not find his phone. Why is that important? The mislaid phone allowed the defendant to be unavailable for 2 days. The mislaid phone allowed him to carry out his plan uninterrupted. And the mislaid phone allowed him to show the police when he eventually reports Ana as a missing person and not have the police question why he didn't contact Ana earlier. The evidence shows that the defendant was methodical. Just look at how he shopped at Lowe's with a list. He planned it with precision. So Jem Lulu came over for dinner on New Year's Eve, and the defendant told Jem that his phone was lost and it was free. Ana was texting throughout the night, including with Bethesda. This is now the third holiday where Ana was concentrating on the other man in her life. When Jem left, Ana was alone. She was with the defendant, the man she was cheating on, the man she was telling to take responsibility for his actions, and the man who had her children. The defendant murdered Ana that morning in their Cohasset home. And this is what the internet history shows. His internet history, written words, he was looking at best way to dispose of a body. Better to throw away crime scene clothes or wash them. Crime scene. Can you be charged with murder without a body? Ana was dead. The defendant killed her, and he began researching how to get her money, how to inherit, how to get away with the crime. And he might have gotten away with it, but he didn't know that his MacBook was syncing with his son's iPad, the same Apple ID. His demeanor changed during the interview on January 8th when the police mentioned the searches on the iPad. Not because the iPad involved his children. He had already involved the children in his lives. But because he knew he was caught. We know he had already involved the 6-year-old when he had the 6-year-old say that he saw his mother when she left the house on the morning of January 1st. The son could not have seen Ana leave the house. The defendant had already killed her. Listen to the recorded interviews. During the January 5th interview, the defendant spoke about what his son supposedly had seen. And the defendant involved the 4-year-old by saying that the 4-year-old hid the defendant's iPhone 13 mini. So, the defendant's phone made a reservation at Nightshade Noodle Bar for New Year's Day, after the defendant told Ana that they were going to have a special party. This is ironic because the defendant was very clear with police on January 7th that he and Ana had no plans for New Year's Day, and the defendant also knew that he would be violating the terms of his federal probation by going to a restaurant on New Year's Day. But let's look closely at Exhibit 170 about the Nightshade Noodle reservation, which was on the defendant's iPhone Mini 13, which the defense just said was deleted. And if you look on page 2, on the bottom of one of the bubbles, you will see that the message was deleted on January 1st at 7:59 and 5 seconds a.m. This happens to be one of the times that the iPhone Mini 13 was unlocked when it was supposed to be missing. The forensics show that the defendant's phone was unlocked 4 times, and it was plugged in on January 1st. You heard testimony that the phone had a password of 197512. And in the January 4th recorded interview, you hear the oldest child needed help with his iPad password, which was 1, 2, 1, 2, 1, 2. The children didn't unlock the defendant's phone. The defendant blamed his misplaced phone on one of his children when he said that the children hid it. But it makes no sense that a 4-year-old somehow unlocked the defendant's phone and deleted that text reminder. Listen to the defendant's recorded interview. The deletion is made when the defendant is supposedly making French toast and playing with the kids. The defendant had access to his phone. Context. The defendant also had access to 2 other phones when his phone was supposedly lost. He had Ana's phone and he had the iPhone SE. And in the recorded interviews, the defendant told police that on New Year's Eve, Ana had an argument with a friend, and as a result, Ana put her phone upstairs in his bedroom.
You said she went and put her phone upstairs after that?
After that, she, let's say it's 10 or 15, and then I remember her putting her phone upstairs because then she came back down without it.
Was, Thomas came down at one point and hung out with you.
Yes. Yeah, exactly.
Was this before, during, or after Thomas was participating as well?
Oh, yeah, Thomas went to bed at, he went to bed, and then he came over at like 9 or 10 or something. I think Ana took a bunch of photos. Jem and I don't have any because she didn't send them to us yet. But I think she sent one to Will Fasto. So that was when, that's when the photo was taken about. So it was maybe 10 o'clock or something like that.
You know where upstairs she put her phone at that point?
Yeah, on her bedstand.
That's not what Jem said. Jem said that Ana was using her phone all night. Melissa Kirby texted with Ana. The defendant was telling investigators a story about Ana's phone. How else do we know that the defendant intended to kill Ana and had a plan for doing so? Look at his internet history. Look at what he did. The defendant set up an area in his basement where he surrounded it with plastic sheeting, wore a tie-back suit, and dismembered his wife, the love of his life. Hacksaw, the best tool for dismembering a body. Then, the defendant got rid of Ana's body. He got rid of her belongings. He got rid of her clothes and bag that he told police that she had, but she supposedly left on January 1st. He threw her in the garbage bags, tossed those garbage bags in different dumpsters. Disposing of a body in the trash. Chatham West apartment rental. The Claremont apartment rental. And police confirmed this with the location data from the SE phone and the iPhone 13 mini. The evidence shows that the defendant did this to hide the fact that he murdered Ana. He could not let Ana's body be found because Ana didn't die of natural causes. The defendant murdered Ana, and then he had to hide the evidence of his crime. Look at his mindset, look at his internet history. Want to get away with murder? Use a special detergent. Can you be charged with murder without a body? Best way to dispose of body parts after murder. When you deliberate, look through the binder of the MacBook internet history. There are no searches of natural causes of death, sudden death, heart attack, aneurysm, stroke, or how to help your children when someone dies unexpectedly or goes missing. The defendant was not sad. Look at his demeanor in the surveillance videos. He's cool and calculating. He's calm. He had plans. On January 1st, he went to the Lowe's store an hour away, even though there were hardware stores approximately a mile from his house. And when he was in Lowe's on January 1st, he wore a mask, and he wore gloves, and he had a list of what he was shopping for. He was calm as he helped bag the purchases. A hacksaw, buckets. He used cash. Does this show confusion, panic, or fear? But he doesn't stop there. He went to CVS to buy hydrogen peroxide. And then he went to Stop and Shop to buy ammonia. No wonder the house was so clean. And on Monday, January 2nd, he went to Home Goods for rugs and candles. And then he went to Home Depot, where he had bought buckets with lids this time, baking soda, and a hatchet. And at some point that day, he got a call from his probation officer. And he lied, and he said that he was picking up his children. He was able to calmly speak with her. No panic. He had everything now that he needed to dismember the woman that he supposedly loved. And he started to take her body and to throw it into dumpsters, since he had to cover up the crime to get rid of the evidence of the murder. This was not a man in crisis. This was a man who on January 4th went to TJ Maxx to buy pants with a store exchange card. He was calm. But Alyssa Kirby texted him on January 4th asking about Ana, and so he called Tishman's Fire a few minutes later and started to pretend to look for her. He called Will Fastel, but he didn't leave a message. He called back later, and then he calmly left a voicemail. No panic. The defendant knew where Ana was. The defendant even texted Ana's sister in Canada and said that she was missing. He was methodical. Look at the text messages. And at 4:30 p.m. on January 4th, the defendant went to Lowe's to buy a trash can. Comfortable. Not panicked. The police would come to the house and talk about Ana. And the defendant had the house ready. The police think his wife is in D.C. He had his phone ready, and he sent text messages to Ana, even though he knew she would never see him. Despite everything that he had done, on January 2nd, the defendant wrote a text message to Ana. I still love you. Ha ha. His joke. The defendant prevented anyone from ever finding Ana's body, and there was no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy without a body, and all that remains of Ana are a few hairs, some blood, and a few things that belong to her. A part of a necklace she often wore, her hunter boots, a black jacket, a purse, her COVID card, and a few other items in the dumpster in his mother's apartment complex. The defendant searched his MacBook for a murder conviction without a body. Please do not allow the defendant's self-serving act of dismembering and disposing of Ana's body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. When you do that, when you analyze the evidence as you deliberate and continue to use your common sense, you will see that the evidence shows there is only one verdict. Find the defendant is guilty of the premeditated first-degree murder of Ana Walshe. Thank you.
I will see counsel at the side of the bench. George, you're my guidepost. Do you need a break for the bathroom? Okay. All for one, one for all. Give you a break for the bathroom. Let us know when you're ready to come back out. I'll be at your disposal.
All rise, please. Jurors, follow me.
Seated. I will give you a quick break as well, but something's been on my mind that I want to discuss now that the closing arguments are over. And that is, I had asked in connection, this relates to the sentencing, at least for the other two counts, and asked the Commonwealth to provide victim impact statements for any immediate family members of Ana Walshe that wish to provide information, and I haven't received that yet. And there might be a good reason for that. I had told you that I was putting off the sentencing until we had a verdict on the charge of murder. But now that it's a Friday, and I don't want this to linger over into the next week, has the Commonwealth heard back from the Department of Children and Family Services?
Your Honor, we've been in touch with them. They are working on their impact statement. They were hoping to have the impact statement impounded. And I can, as soon as we're done here with the charge, I will speak to the attorney that I've been dealing with. They've been working very hard on this. They're certainly worried about their privacy interests of the children and the social
I think there's a
work.
valid privacy interest of the children, and I'm highly likely to impound it, obviously, with the exception of counsel for both sides being able to see it so that they can make appropriate arguments as a result of the victim impact statement.
I think the department will be very happy to hear that. And they also, much of what they have is through a social worker privilege, so they're concerned about that as well. But as soon as we break, I will be happy to have that conversation.
Well, I'm happy to hear that there's forward progress because I guess I assumed, because I hadn't heard anything, that you were still not getting the answers to the questions you were asking.
No, quite the opposite. They've been working very hard on this.
All right, I appreciate that.
Thank you.
Anything anyone needs before I step off the bench briefly? Thank you.
All rise. Seated.
Stand up.
Running, Your Honor.
Yes, please. Just so it's on the record, everybody saw the small edit I made to the verdict slip, and everyone's fine with it. Is that right? Everyone's nodding. Thank you.
All rise to the court, please. Jurors entering. Court is back in session. You may be seated.
Welcome back, jurors. Jurors, I'm going to go through the remainder of the instructions, the final stage of this case before you will get the case to deliberate. The intent of the second part of the instructions is to give you some assistance in determining how you go about deciding whether the Commonwealth has proven each element of the indictment is true beyond a reasonable doubt. For the charge, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of the charge. You may not find the defendant guilty on the charge just because you think the defendant did something else that was wrong or improper. Your decision as to the charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip. When all 12 jurors agree on the verdict, the foreperson should check off that verdict and then sign and date the verdict slip, in ink. In a little while, I'll go over that verdict slip a little bit more. For the charge, if you all agree that the Commonwealth has proved every element of murder beyond a reasonable doubt, then you should find that Mr. Walshe is guilty. On the other hand, if you all agree that the Commonwealth did not prove one or more of the elements of murder beyond a reasonable doubt, then your verdict must be not guilty. Let me talk about your role. Jurors, you have the most important role in this trial, because you will decide who and what to believe, and whether the Commonwealth has proved Mr. Walshe's guilt beyond a reasonable doubt. You must be completely fair and impartial and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly and carefully. Do not be influenced by the nature of the charge or the possible consequences of your verdict. And do not let your personal feelings about any person, criminal charge, or anything else influence your decision. All parties who come before the court stand as equals before the bar of justice. That a case is brought in the name of the Commonwealth does not entitle the prosecutor to any special consideration. Your verdict must be based on the law as I have given it to you, and on the evidence and the facts as you find, and nothing else. By contrast, my job as the judge is to impose sentence if the defendant is found guilty. Therefore, you are not to consider the sentencing consequences of your verdict at all. That's not your responsibility. So please put any issues about sentencing out of your mind. Let me next talk about evaluating the evidence. You must decide this case based only on the evidence that was presented at trial. You may not decide this case based on anything else. Do not consider anything you have read, heard, or seen outside of this courtroom. Those things are not evidence, and you may not base your verdict on guesswork, speculation, or suspicion. Let me talk to the important topic of the defendant not testifying. As you know, Mr. Walshe did not testify in this case. You may not hold that against him. Mr. Walshe has an absolute right not to testify because, as I've explained, he is presumed to be innocent and does not need to do anything to convince you that he is innocent. It does not matter why Mr. Walshe did not testify. It's not relevant to what you must decide, which is whether the Commonwealth has proved, based on the evidence presented at trial, that Mr. Walshe is guilty beyond a reasonable doubt. The fact that Mr. Walshe did not testify is not evidence. You may not consider it or even discuss it in deciding this case. Let me next talk about witness credibility. During this trial, you've heard from a variety of witnesses. With reference to any and all witnesses who have testified before you, you have wide latitude. As a jury, you can believe every single word that a witness says on the witness stand, or you can disbelieve every single word that a witness says on the witness stand. You may decide to accept parts of a witness's testimony and to reject other parts of his or her testimony. That's for you and you alone to decide. If there are any conflicts in the testimony, it is your function to resolve that conflict and to determine where the truth lies. In evaluating the credibility of witnesses, you may use various tools. You may consider the ability, the opportunity, and the reliability of the witness to see or hear something in the past, and then remember and later testify about it before you in this courtroom. You may consider the conduct of the witness, his or her manner of testifying before you, any inconsistency you may have found in the witness's testimony, any interest the witness may have in the outcome of the proceedings, any bias or prejudice or hostility the witness may have demonstrated while testifying before you, the level of accuracy of the witnesses testifying before you, and the reliability of the testimony as it developed before you. These are some of the tools that you have at your disposal to resolve disputed issues of fact in this case. There's one more point about witnesses that I'd like to specifically address, and that's expert witnesses. This term refers to witnesses who have specialized training or experience in a particular field, generally in cases that are tried in our courts, both civil and criminal. Witnesses may testify to facts that are within their own personal knowledge. That is, things they've personally seen or heard or felt. However, in a variety of cases, this one included, issues arise that are beyond the experience of laypersons, and in those types of cases, we allow a person with specialized training or experience, we call them expert witnesses, to testify not only to the facts, but to their opinions, the reasons for his or her opinions, on issues that are within the witness's field of expertise and are relevant and material to the case. Because a particular witness has specialized training and experience in a field, doesn't put that witness on any higher level than any other witness. And you are to treat the expert witnesses just like you would treat any other witness. In other words, as with the other witnesses, it's completely up to you to decide whether you accept the testimony of the expert witnesses, including the opinions that those witnesses gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to reject the testimony and opinion of such witness in whole or in part if you determine that the witness's opinion is not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained, keep firmly in mind, jurors, that you alone decide the facts. If you conclude that an expert witness's opinion, not based on the facts as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember, jurors, that expert witnesses don't decide cases, juries do. In the last analysis, an expert witness is just like any other witness, in a sense that you alone make the judgment about how much credibility and weight give the expert's testimony and what conclusions you draw from that testimony. Let me next talk about graphic photographs. The Commonwealth has introduced certain photographs showing items taken from various trash bags retrieved from 300 Forest Street, Peabody, during the investigation of this case. You will have those photographs with you during your deliberations, as all the evidence will be with you during deliberations. Some of those photos, as you've seen, are not pleasant. Indeed, some may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by those photographs. Related to this, sometimes evidence is presented that produces in jurors an emotional response. For example, it is natural and understandable to feel sympathy and empathy when you hear or see testimony that suggests what might have occurred to Ana Walshe's body after her death. But as jurors who have taken an oath to follow the law, I instruct you that you must separate any emotional response or reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the nature of some of the testimony and video evidence. You must find the facts in this case based only on the evidence. You can't find facts or base your decision, again, on sympathy, anger, passion, or prejudice, or pity for or against either side in this case. Rather, again, jurors, your verdict must be based solely on the evidence in this case and my instructions on the law. So what is evidence? I told you earlier that repeatedly that you must decide this case based only on the evidence presented at trial. The evidence consists of the testimony of the witnesses, as you recall it, the things that were marked as exhibits, and the stipulations, or I told you those agreements, of the parties, which I read into evidence. You will have the exhibits with you in the jury room. Things that were marked for identification aren't exhibits, so don't be looking for those, because they're not exhibits, and you won't be able to consider them. Other things that are not evidence and you may not consider when deciding this case are as follows. The fact that the defendant had been indicted and charged with a crime, not evidence. Questions that the lawyer asked of a witness are not evidence. Only the answers given are evidence. For example, if a lawyer asked, wasn't it raining outside? And the witness answered no, or said, well, it was cloudy. The question is not evidence that it was raining. If a lawyer asked a question and I sustained an objection and therefore the witness didn't answer it, then neither the question nor the fact that the witness did not answer is evidence. If I struck or told you to disregard any part or all of an answer by a witness, then the part of the testimony that I struck, not evidence, you may not consider it. Anything that you may have seen or heard when the court wasn't in session isn't evidence. The opening statements and closing arguments of the lawyers are not evidence. And if your memory of the testimony differs from what the attorney said in their closing arguments, you should rely on your memory. Any notes that you've taken, they're not evidence, but you may use your notes to refresh your memory of the evidence. As you know, evidence can come in many forms. It can be testimony about what someone saw or heard or smelled or felt. It can be someone's opinion, and it can be an exhibit. Whether the evidence is direct or circumstantial, sometimes we call that indirect, The Commonwealth must prove the defendant's guilt beyond reasonable doubt from all of the evidence in the case. Some evidence proves a fact directly. For example, if a witness testifies that she saw and felt it raining outside before she came into the courthouse, then that's direct evidence it was raining. Some evidence proves a fact indirectly, circumstantially. For example, let's say a witness testifies that he saw someone come into the courthouse wearing a wet raincoat and shaking water off of an umbrella. That's indirect evidence that, if you believe it, might lead you to conclude that it was raining outside, even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove something is true, but it is evidence from which you could logically conclude that it is. We call this drawing an inference. We all draw inferences every day. We take some known information, we apply our intelligence and common sense, then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you make when you're not sure about something. Sometimes you can draw more than one inference. Also, you may draw an inference even if it is not necessary or inescapable, so long as it's reasonable and warranted by the evidence. You have to decide, jurors, which inferences are reasonable, and decide which seems more reasonable to you. It makes no difference whether evidence is direct or indirect. Commonwealth may be able to prove a criminal charge with direct evidence, indirect or circumstantial evidence, or a combination of both. Let me next talk about credibility. An important part of your job as jurors is to decide who and what to believe. You may believe everything a witness says, part of it or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or deliberately lying. If you conclude that a witness lied to you about something, then of course you should not believe that part of the testimony. Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without meaning to do so. A witness may recall seeing or hearing something but actually be mistaken. For example, the witness might not have paid close attention or might have misunderstood what was happening. Or a witness's memory of what happened could be incorrect. If you conclude that a witness tried to be truthful, but that some part of that person's testimony was inaccurate, then you should not consider the inaccurate portion. How do you decide whether you believe a particular statement by a particular witness? Well, ask yourself, did the testimony seem reasonable or probable? Did the witness have a good chance to observe what happened? How much attention did the witness pay? Did the witness's memory seem accurate? Was the witness's testimony consistent with other evidence, or instead contradicted by other evidence? How did the witness behave and answer questions while on the witness stand? Did the witness have any motive for testifying in a certain way, or have any other bias that may have influenced the witness's testimony? You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way as you would evaluate anyone else's testimony. You must not automatically believe or automatically disbelieve a witness just because a person is a police officer. Moving next to the importance or significance of evidence. It's up to you, jurors, to decide how important each part of the evidence is, whether it's testimony by a witness or an exhibit, whether evidence is direct or indirect. You should give each piece of evidence whatever significance you think it deserves. You're not required to believe something simply because it appears in an exhibit. It's up to you to decide how important any exhibit is. You do not have to treat testimony by a witness as more or less significant than the exhibits. You may find that a witness's testimony is very important, or that an exhibit is more important. That is up to you. Next, I want to talk about the alleged victim's state of mind. You heard evidence of statements Ana Walshe allegedly made to William Fasto, Jem Bootlu, and Alyssa Kirby. Those statements are admissible for the limited purpose of establishing Ana Walshe's state of mind, as may be relevant to the defendant's motive or intent to kill. Those statements cannot be considered as proof of the criminal acts charged or as proof that the defendant had a bad character or a propensity to commit any criminal offense. Let me next talk about motive. First, motive is not an element of the offense of murder, and the Commonwealth is not required to prove or show motive. Evidence of motive can be relevant to the issue of intent. Second, an absence of evidence of motive may tend to raise a reasonable doubt. Third, even a total lack of evidence of motive would not necessarily raise a reasonable doubt as to the guilt of a defendant, so long as there is other evidence produced that is sufficient to prove the guilt beyond a reasonable doubt. Let me now move to the area of something called consciousness of guilt. I spoke earlier about inferences and the drawing of inferences from indirect or circumstantial evidence. At this point, I want to talk about a particular type of inference based on a legal doctrine called consciousness of guilt. In the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest and that he may have taken steps to conceal Ana Walshe's body after her death. I want to stress to you that I'm not suggesting that he did so, or that you should find that he did so, but only pointing out that there was evidence to that effect. It's up to you to decide what evidence to accept or reject, and what facts to find from the evidence. I point to that evidence to illustrate the legal point involved. If you find from the evidence that the Commonwealth has proved that the defendant provided false information to the police and or took steps to conceal the body of Ana Walshe after her death, then you are permitted to consider whether such actions indicate feelings of guilt by the defendant, and whether, in turn, such feelings of guilt might tend to show actual guilt on the charge. You are not required to draw such inferences, and you should exercise great caution, and do not do so unless they appear to be reasonable in light of all the circumstances in this case. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, or such feelings are sometimes found in innocent people. If you decide that such inferences are reasonable, it's up to you to say how much importance to give them. But remember that such evidence is never enough by itself to convict a person of a crime. You may not find a defendant guilty based upon such evidence alone, but you may consider it along with all of the other evidence in this case. Next, I want to speak to impeachment by the defendant's prior or subsequent bad acts. The only charge the defendant is now facing is the charge of murder. You have heard mention of other acts allegedly done by the defendant, namely, that he was charged in 2018 and sentenced in 2024 in a federal case involving art fraud, and or that he lied to the police, and or that he disposed of the body of Ana Walshe, and or that he lied to his federal probation officer. You may not take the defendant's prior or subsequent acts as a substitute for proof that he committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. You may consider this evidence solely on the limited purpose of the motive, state of mind, intent, plan, or absence of mistake or accident on the part of the defendant. You may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed these other bad acts, that he must have also committed murder. It would be extremely unfair to consider this evidence for those purposes. Moving next to your notes. Many of you have taken notes during this trial. Your notes may help you remember the evidence, especially the testimony, but of course they're not an actual transcript or official reporting of what was said. So use your notes only to help you remember what you saw and heard in the trial. Whether you took notes or you did not, you must rely on your own memory of what the witnesses told you. After the trial is over and you've returned your unanimous verdict, the court officer will collect your notes and I will order that they be destroyed. During the trial, the lawyers occasionally, as was appropriate, objected to questions posed by the witnesses. They may have asked to strike something or, in essence, erase something you saw or heard. When a lawyer believes that something would violate those rules of evidence we've talked about from the beginning, that's the only way they have to let me know. And so don't hold it any against the lawyers that they made such objections. It's part of their job. I want to next turn to fairness. Each of you has taken an oath and promised to be fair, and I'm sure you want to be fair, but that's not always easy. Part of being fair is being willing to examine your decision-making process to be sure that you base your decisions as jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions, and they exist even if we're not aware of them. We all have them simply because we're human beings. They affect our actions and decisions without us even realizing it. As a judge, I have the same problem as everyone else. So let me share a few strategies that I found to be useful. These strategies will help you make sure that you decide this case based, again, only on a careful examination of the evidence and on the legal rules that I'm teaching to you. First, slow down. Do not rush to a decision. Take time to consider all of the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we might not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were from different social or economic groups, or different ages, genders, gender identities, or sexual orientations, or came from a different racial or ethnic background? Fourth, listen to each other. Other jurors may have different points of view. If so, they may help you make sure you're focusing on the facts. Of course, other jurors could be influenced by their own unstated assumptions. So don't hesitate to share your views. You should participate actively, particularly if you think other jurors are overlooking or undervaluing evidence that you think is important. When you explain your thoughts to your fellow jurors, you help everyone focus on the evidence. If you do these things, then you'll play your part in reaching a decision that's as fair as is humanly possible, and that's your obligation as jurors. Now I'm going to move to giving you some instructions about how to conduct your deliberations. Privacy. The first point you need to know is that you must keep your deliberations secret. You should not tell anyone outside of the courtroom, not even me, anything about your deliberations. For example, please do not tell me or anyone else the results of any votes that you may have taken before you all agree on a unanimous verdict. You must not tell anyone about how your discussions are going or what other jurors are saying. If you need to communicate with me before you reach a unanimous verdict, you should send me a written note and a form that you all agree on. The court officers have it. It must be signed by your foreperson, and I will discuss your note with the lawyers, and then I will either send you a response in writing, more likely, or bring you into the courtroom, less likely, and respond to you in person. If you do send me a note, do not mention any votes that you have taken or anything else about your deliberations. Do not talk about this case unless all of you are present and no one else is in the room. If one of you needs to leave, even for a moment, the rest of you should stop deliberating until that juror returns. That includes the bathroom breaks, because I know that's right inside your spot. If we break for the day without you reaching a unanimous verdict, you must not communicate with the other jurors about this case until the next day, only after we gather in the courtroom and I ask you to resume your deliberations. As you work to decide this case and until I accept your verdict, you must not communicate with anyone else about the case except each other. And you must not do any kind of research about this case. You may not do so in any way, including with electronic devices, a cell phone or a tablet. This also will apply to the alternate jurors. We talked about those alternate jurors. The law permits only 12 jurors to participate in deciding a criminal case. There are 16 of you here. So in a few moments, our clerk is going to randomly select 4 of you to be what we call alternate jurors. The other 12 of you will work together to decide this case. We chose 16 of you originally in the case, just in case one or more of you got sick or needed or had some other unexpected emergency. If you are chosen as an alternate, your continuing service is still very important, and you must comply with all the rules that I placed on you. The alternate jurors will stay in another room, and you can't have your own private deliberation. You can't discuss the case with each other or with anyone else for obvious reasons. If we lose a deliberating juror in the group of 12 because of some personal emergency or sickness, then I will send one of the alternates into the jury room. If this happens, the deliberating jury will have to restart its discussions from the beginning. One of you is going to serve as the foreperson of this jury, and we will discuss who that foreperson is going to be in a moment. Foreperson will make sure that each of you has the chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinion about the case is no more important than the opinion of all of the other jurors. Once you agree on a verdict, the foreperson will fill out the verdict slip and will report your verdict in court. I want to next talk about making decisions as a group. When you work together as a jury, you will be making decisions as a group. This kind of decision-making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed, and each of you will have insights that will help the other jurors make sense of the evidence and reach a verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You've all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will, well and truly, try the issues between the Commonwealth and the defendant according to the evidence and the law. So, you are all equally qualified to reach a verdict. I have a few more suggestions that might help you work better together. First, you should discuss and analyze the evidence before you take any votes about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as jurors, and as the other jurors talk about the evidence that they found important, listen. In order for this process to work fairly, each of you should hear every other juror's insights and ideas. Please be open to them, since they might influence your own thinking. Fourth, don't be shy. As in any group, some of you may feel more comfortable than others sharing your thoughts, but you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one that remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective your deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept a decision just because other jurors think it's the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, jurors, each of you must decide this case for yourselves. One last pause to consult with the attorneys. So I talked to you about a four-person, and I talked to you about what we call reducing the jury. That is, reducing you down from 16 to 12. I'm appointing juror number 138 in seat number 6 as the four-person of this jury. Our clerk is now going to randomly select 4 of you from among all of the jurors except the four-person to serve as alternate jurors. So what's physically happening is juror number in seat number 6, juror number 138's number is coming out of the thank you, Madam Clerk.
Your Honor, numbers 1 through 16, with the exception of number 6 of this. Your Honor, our first alternate is a juror in seat number 12.
Grab me. Then no, book him to Solomon.
Our next alternate is a juror in seat number 5. 5. Juror in seat 15. And our last alternate, Your Honor, is juror in seat number 11.
One last substantive thing that I want to go over with you jurors before I really get into the finally the concluding remarks. And that, as I said to you earlier in this second part of the charge, that I would go over the verdict slip. There is a verdict slip, and I know that you can't, unless you have stellar vision, you can't see it from where you are, but you can get the layout of it. I'll read it to you. The verdict slip reads, count 001, on or about January 1st, 2023. And it puts the charge, murder in the first degree with deliberate premeditation. That is the charge. We, the jury, find the defendant, and there are three options. Not guilty, guilty as charged, murder in the first degree, guilty of murder in the second degree. And there's a place to sign it and date it. And again, the foreperson in pen, not pencil. This time, Madam Clerk, I'm going to ask you to swear in the court officers.
Do each of you solemnly swear or affirm that you will take charge of this jury, keep them in some secluded places where they can read. Each not speak to them or suffer anyone else to speak to them except by order of the court or ask that they read and say
I will.
So now the deliberating jurors, the 12 of you, are going to go and start your private discussions. Have confidence in what you are about to do. By serving on this jury, you carry out a long and proud tradition of citizens of the Commonwealth of Massachusetts serving on jury trials and deciding criminal cases. If you are honest, thoughtful, and fair, you will be able to reach a fair and just verdict, dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in the courtroom during this trial. All we expect from you jurors is that you decide this case with integrity and principle. And with that, I'll ask you and let you go back to the deliberation room to begin your work. Thank you very much.
Court, all rise, please. Jurors, take your notebooks with you and follow me.
So I will, as I said to you at the side of the bench, there's some small edits necessary in fact. You may be seated. There's some small edits that I need to make to the instruction, and I'll make those now, take the draft off, make sure the numbers are all right for the index that goes down with them. Anything else that the parties need to bring to my attention before I do that?
We received materials to secure those items, and we're going to work
Oh,
on
can I
that.
see that? Are they been secured yet, or you're going to?
We're going to secure them. I haven't had the opportunity yet.
All right, let Madam Clerk know when that's done, because I do want to take a look at those before they go in. And of course, our court staff as well, court officers might want to take a look at those to make sure that they're comfortable with what's going into the jury room.
And we thought we'd cut up pieces of parchment paper for the jurors if they need to examine anything that they can place on their table.
Do you have a roll, they can do it themselves?
We have a roll. We can give them scissors if you want.
Well, cut them off.
That's why I put that out there.
All right.
Thank you, Ron.
I think you're pretty familiar that I have a 10-minute rule, which means at all times, Madam Clerk should be careful that you should be able to return to the court within 10 minutes, all right? I won't take it further between the hours of 1 and 2 on any day to get the opportunity to tend to your other work.
Thank you, Ron.
All rise. Seated, court's in session.
Everybody saw the question?
Yes, Your Honor.
My suggestion is that there are 265 exhibits, and I ordinarily have sent in an exhibit list that the parties have reviewed, and I would think that would be an appropriate way to assist them in their evaluation of the evidence, but it needs to be cleaned up. In particular, on a quick review of it, photo 52 should say something other than butcher paper.
And 189?
Also the same term?
No.
What were you calling it? What kind of paper? Bench?
Bench paper.
That term is used throughout, so what is it that is, that term is used in other numbers, so is it something about that particular photo that is problematic with that description?
Oh, I
mean,
just don't like it, but
I know you don't like it, but I'm trying to distinguish between, I think there was one witness who used that term butcher paper as opposed to bench paper, and I don't think it was the witness that was associated with that. This is just the old-fashioned terminology that people often use to describe that paper. I think I used it at the side of the bench one time, not in front of the jury, but just with you. But I think that is there's a more neutral characterization that would be appropriate and more in line with what the witnesses actually testified to. But as to the other language in 189, it seems to me that that's what the witness testified to, right?
that's right.
Yes, Your Honor.
Anybody, let's all take a moment to look through the list right now and see if there's anything. I'm going to do that right now. The answer to their question is 97, by the way.
Yes.
Let me just take the time to look through these, and you do the same.
Other than that, that's the only blood clots in it.
aside from that one suggestion, the change.
Okay.
Oh, still miss one? 182.
All right, so I'm going to write back to the jurors, and I will give them the name of, or the number of the photo, which is, I'll answer it as exhibit number 97, and here's an exhibit list to assist you.
Thank you, Your Honor.
Here you go, Madam Clerk. If you want to look at it, you're welcome to. It's pretty straightforward. Thank you.
Court's in recess.
It was the Wild West. Closing session, may be seated.
Your Honor, we're back on the record in Commonwealth versus Walsh.
Thank you. As is my custom, at 4 o'clock, I send in a note on every day the jury's deliberating, asking if they want to stay until 4:30. That note will be marked as the next exhibit for identification. And it gives them the option of staying until 4:30 or suspending and coming back on Monday in this instance, and they've elected to do the latter. So we'll bring them in, send them on their way.
R for ID, so marked.
Thank you.
All rise to the court. Jurors entering.
I'm gonna go see Mom, but otherwise I would. Maybe on Monday if we're.
Court is back in session. You may be seated.
Welcome back, jurors, to the courtroom. Again, thank you for your work today. And I'm going to send you on your way for the weekend. I remind you, jurors, that the rules still apply. They will apply until you reach your unanimous verdict. I remind you of those rules now, jurors. Don't speak to anyone about this case. Don't do any research about this case. Continue to have open minds as you evaluate the case and as you wait to see if you are going to evaluate the case. Don't access any social media or any news media over the weekend. Hope you have a good weekend, get some rest, and we'll see you back here ready to work on Monday morning. Thank you, jurors.
Thank you.
All rise to the court, please. Jurors, follow me.
Thank you.
Just as short as council, make sure you're back here a few minutes before 9 o'clock in the morning on Monday. Have a nice weekend.
Thank you.